Well, good morning, everyone. This is George Spees for the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar, where we're going to be discussing basics of the right to know law. A couple preliminaries as we're getting started here. First, you should know that this session is being recorded, and the recording will be posted to the OOR's website here in a day or so once the session has concluded. That's handy if if you want to use it for future reference, or if you have a colleague who perhaps couldn't attend this morning, you can refer them to the website and they can take a look at it there. If you'd like your own local copy, you can download from the website, which I believe is first put over on YouTube, or you can send us a flash drive, and it's possible that someone here on the administrative staff would be able to copy that over for you. If you've never attended one of these sessions, it's basically PowerPoint based with me talking in the background. The PowerPoint is also loaded on the office's website. Go to the training tab, scroll down, and there'll be a tab there for all of the presentations for every webinar and for every training session that we do. You're welcome to download those. Again, they may prove useful for future reference, or maybe you're having some local training. Or it's possible that, again, you may have a colleague who wasn't able to attend this morning and, you'd like to walk them through the presentation. You're welcome to do that. They're considered public records, so have at it. As I stated, this is a PowerPoint presentation with me narrating, so let's talk about questions. You're welcome to type your questions in the chat feature, but I have two conditions that have to be met here. First is that, we're talking about the right to know law, so let's stay on topic and keep your questions pertinent to that. The second is that I would ask you to be as brief and direct with your questions as you possibly can be. Occasionally, we'll get a situation where someone will type in several paragraphs, and honestly, it's just awkward for me to sit here and try and read through it while everyone else is waiting patiently. I'll do my best to answer your questions live. But if it looks like you're talking about a situation that is, specific to your agency, or maybe it's an unusually complex question, we'll do one of two things. We'll wait until the end of the presentation. I'll return to it, and I'll try to address it for the good of the order. Or we'll take the conversation offline. The phone number and URL for our website are currently on the screen. And what I would do is encourage you to email or call the office with your questions. And first, the administrative staff will screen it. They're very knowledgeable about the right to know law. Good chance they'll be able to get you headed in the right direction. Or if need be, we'll escalate it to one of the executive staff. And usually when that happens, someone will get back to you within 24 hours. We realize if you're contacting us, there's a good chance it's important to you, and you're probably working with a deadline. So we want to make sure that someone gets back to you. We can't answer your requests for you. We can't provide legal advice, but what we can do is steer you to, perhaps legal precedent and how we've ruled on similar issues, and you can draw your conclusions from that. But all that being said, all these preliminaries out of the way, let's get started with the presentation and talk about the right to know law. First thing we want to do is talk about why it's important. There we go. And, in a general sense, we're talking about access, transparency, and good government. There's a fundamental statement that I like to put out there in these training sessions, and obviously here it is in red. The purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, seems pretty basic, and it should be, but there's a lot of misunderstanding, at least initially, when people encounter this law as to what it means. People see that term right to know, and they interpret it as some form of government Google, and they'll submit questions to an agency, and the agency perhaps mistakenly thinks that, okay, it's our job to run around and find the answer to these questions. And you can see by the fundamental statement that that is not the case. Right to know law is to give the public access to public records. The government agency is not required to create a record or provide a record that it doesn't already have, okay? In most cases, when we talk about possession, I'm going to say, 98, 99% of the time, the agency must have the record in its possession in order to determine whether or not it's public and then provide that record in response to an open records request. And when I use the term right to know law or open records law, the two terms are interchangeable, okay? But officially it's known as the right to know law. So all that being said, the fact that the agency is only obligated to provide public access to public records, there are some conditions associated with that. And first is the starting point. It is that every record that an agency does have in its possession is presumed to be public, okay? That's where you start from. There are no inherently non-public records, unless the agency can meet its legal burden of proving that a record is not public. Okay, so the starting point is everything's public, but the agency, if it's not comfortable releasing a record, it has to meet a legal burden to prove that that record should not be released into the public domain. Okay, now that sounds rather daunting if you're with us today from the agency side of the equation. But I can tell you that there are a number of tools within the right to know law, as well as some other laws that we need to be concerned with, that make that job easier than what it appears at face value. And we're going to talk about that as we proceed throughout this presentation. There are records that are inherently public, and we'll talk about those, but bearing the burden of proof may not be as difficult as your initial impressions lead you to believe. Another point that we need to make is the fact that the right to know law is not a confidentiality law, okay? The right to know law doesn't limit, per se, what the agency can release. First offhand, you can give out public records without any mention of the right to know law. I can walk into your office as a citizen during budget time, and I can ask, may I have a copy of the budget, please? And let's say you have a stack of budgets sitting there on your counter. Well, there is absolutely nothing in the right to know law that prevents you from simply handing me a copy of that record, that budget. Okay, there's nothing in the right to know law that says I must submit a right to know request in order to get a public record. Now, an agency can require that, okay, because the right to know law affords agencies a great deal of discretion in how they manage their open records program. So if an agency decides before we release any public record, we must have a right to know request, they can do that, but there's nothing in the right to know law that dictates that they must do that. You can simply hand me a copy of that budget or any other public record for that matter. Okay. And what we recommend, and a number of local agencies and state agencies are already doing this, is that if there are commonly requested public records that you notice a pattern in your right to know requests or what people are asking for, use your social media as business platforms to go ahead and post those public records preemptively. So there are such things as budgets, contracts, salary information, purchasing documents, and many others that will define as inherently public. Okay, there's nothing secret about them. They are documents that reflect the work that our government agencies are doing on behalf of the public that would obviously be shared. So you put those on your websites and you use your websites as business platforms so that these commonly requested records are already out there. You'll notice two things when you do this. First is the hits on your website will immediately start going up because it's the way people do business nowadays, or they expect to do business. It's much more convenient for them to sit in their, their offices or the comfort of their family rooms and search your websites for the records that they're looking for, as opposed to submitting a right to know request. And in order to do that, maybe they have to take an afternoon off of work, come down to the office and submit it, and then potentially wait up to 35 days before they get the response to the right to know request. It's much easier if you already have it posted on your website. It's much more customer friendly and it's good public service. The second thing you'll notice is that the number of right to know requests that you receive will start going down because these records are already posted in the public domain. So let's say then you've done this and you receive a right to know request for a copy of the budget. Your response, and this is consistent with language in the right to know law, is that the budget is on our website. Here's the URL for that particular page. You have provided a valid response to that right to know request, consistent with language in the right to know law. So while it may be a little more effort up front, in the long run, it saves you more work because right to know requests go down. The right to know request that you do receive, you can simply say, that's on our website. And you create a more conducive relationship with the public that you're there to serve, because you've more or less entered the 21st century by using your social media, your websites, Facebook pages, whatever, to provide this information preemptively. And that's just the way, especially the younger generations expect to do work with, business and government agencies and so forth and so on. Okay. Let's talk about what agencies are required to do under the right to know law. And when I use the term agencies, it could be at the state level, it could be any cabinet level department, any board, commission, authority created by statute, and at the local level, it's pretty much the same. Cities, boroughs, townships, school districts. School districts, an extension of that would be charter schools. Again, authorities created by statute, so forth and so on. So let's presume that the agency is subject to the right to know law. So the first thing they have to do is appoint an agency open records officer, what we refer to as an ARO. Okay, this is the person responsible for receiving requests, processing those requests, and ultimately responding to those requests. Now, this person doesn't have to be at a certain level within the agency, okay? It could be the CEO, it could be an elected official. Any employee within the agency can serve as an agency open records officer. An agency can also have more than one ARO. Okay, it's not uncommon for, let's use boroughs as an example. One borough may have a single right to know officer or ARO. You go 3 miles down the road to the next borough, and they may have one who handles the administrative side and a second who handles law enforcement for the police department. Okay, as long as it's clear to the public, who do I give this right to know request to, or who do I see about obtaining a public record, I think you'll be okay. But, for instance, last count, the city of Philadelphia has 40 AROs, just given the size of their organization and the breadth of services that they provide. But again, as long as it's clear to the public, who do I see? I think you'll be fine. Now, an agency may come up with its own rules and policies for administering their open records program, as long as it doesn't conflict with the right to know law or any rules or policies promulgated by the Office of Open Records. Typically, where we run into conflict here is with pay issues, or cost issues. An agency may attempt to implement some fee that is inconsistent with the fee schedule promulgated by the Office of Open Records. And otherwise, typically there's not a conflict, but that's usually where we run into issues there. An agency can also, let me talk about rules and regulations here just to shed a little more light on this and show you some of the flexibility built into the law. There is, for instance, there's a provision within the right to know law that says an agency may accept anonymous requests. Okay, well, the key word in there is may, because in Pennsylvania, there's another law known as the Statutory Construction Act, which defines or explains that word may also means may not. Okay, again, it gives you, affords you a level of discretion. So under the right to know law, because that word may is in that provision, you can interpret that as meaning that an agency may not accept anonymous requests. So you could invoke a policy where you're saying we'll only accept right to know requests where the person is identifying themselves. And this particular issue has been litigated in the Office of Open Records, and I believe higher courts have agreed that this is a valid policy afforded by the flexibility built into the right to know law. Okay, so an agency, like I said, could adopt a provision that says we will only accept right to know requests where the person is identifying themselves. And there are other examples in the right to know law as you read through it and read the fine print, read the definitions and so forth and so on, where you'll see that agencies do have a degree of flexibility and you can come up with your own local policies. You can also come up with your own form, and honestly, most agencies do that. They like to have their seal at the top, perhaps contact information for the arrow. There are some other agencies that will simply use the state form. And I should say that in addition to your own form, you must accept the state form. If someone comes in with a copy of the state form, which can be found on the OOR website, there's not necessarily anything special about it, but you must accept that form if it's provided. You can have a policy that says we're not going to require any forms. Okay, someone can simply write us a letter or an email, and that's acceptable as a right to know request. However, given the flexibility in the right to know law, you can have a provision saying we'll only accept right to know requests that are either on our form or the state form. It's up to you as to how you want to manage your programs if you're joining us today from the agency side. Okay, and then finally, we ask that you let us know here at the Office of Open Records who your arrow is and how to get in touch with them. On our website, we have a database of all the arrows statewide, okay, but it's a voluntary system. Some of the names are populated through a link we have with the Department of Community and Economic Development, but for the most part, we're relying on agencies to provide us the updated information. And it's for a couple of reasons. People will, look at your website and they won't be able to figure out who's the right to know officer, so they'll contact our office. And we say, well, check out our website, the database, and hopefully you'll find somebody there. Or if an appeal is filed against the agency, our point of contact will be this agency open records officer. So it's important that we know who they are so we can reach out to them and get them started on the appeal process, which is, a very important segment of this whole right to know process. Okay, postings, yeah, you have to have postings. On your bulletin boards within your physical offices, And if you have social media, it should be either on your website, your Facebook page, or whatever else you're using to notify the public as to what's going on with your agency. The purpose of the posting is to educate the requester. My experience is that the more the requester knows about the process, the better the whole interaction will go. Okay. People don't like being surprised when they're dealing with really any situation. So the more information you can put out there about your agency's right to know process, the smoother that transaction is going to go. So on your posting, contact information for the arrow. Again, look at it from the citizen's perspective. Who do I go to get a public record? Who's the person? Then contact information for the applicable appeals office. Okay, and this is if you deny access to the records, the person has the right to appeal. Well, you need to let them know that. In 99% of the cases, it's going to be the Office of Open Records. So give them the URL for our website. And we ask that you do that because we're fairly automated here. Everything's online. We prefer that people file appeals through the website because that feeds directly into our docketing system. Then you need to have a form available for them to file a request if you require a form. Okay, because they may not have one. They may not know how to get one. So you must have that form available either on your bulletin board, or if you have a website, it has to be on your website as well. And then also post any of those local regulations or policies that your agency has adopted. Again, before someone enters the playing field, it's helpful that they know the rules of the game. So put as much information out there as you can to help the public, and that'll lead to a smoother transaction and make your job easier in the long run. Okay, what can't an agency do relative to the right to know law? Well, the first is that you cannot adopt a policy that limits the number of records or requests that a person files in any particular time frame. Okay, you can't say, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. Now, if she's inclined to file a dozen requests in a week's time, the law allows her to do that. Also, you cannot compel a person to tell you why they are filing a right to know request. You can't deny a request based on the reason or what you think that reason may be. Okay. Now, let me go off script a little bit and say the greater majority of people filing right to know requests are doing it for legitimate reasons. They need a public record in order to solve some problem that they currently have. However, we also acknowledge that there are a handful of people who, for whatever reason, the relationship between the agency and that person has broken down, and they have decided they're going to be a pain in the neck. So they've weaponized the right to know law, and they submit a bunch of frivolous requests. There are things that the agency can do to alleviate that problem. What I would recommend is, check out the training schedule and sit in on the payment issues and the right to know law session that we do. My experience has been that if people are willing to pay a nominal fee for access to a public record, most people are not willing to pay any money to be a pain in the neck. Okay, so I think you see where this is leading. I'm just going to recommend sit in on that class. We will be talking about payment issues briefly through this session, but sitting in on that other session where we talk specifically about the payment side of the right to know law may help you out when it comes to what we call frivolous or problem requesters. And if you're joining us today and you're one of those frivolous requesters, well, shame on you. Please stop. Okay, so the other thing that I want to say is that, like I said earlier, just to repeat myself, you cannot compel a person to tell you why they are filing a right to know request. The law, however, doesn't say that you can't ask. And occasionally, by knowing the reason why a person is seeking a public record, you can help each other out in your efforts to find that public record and provide it to the public, because they may not know the specific record that they need. It's just that they have a problem. You can solve it by providing them with the appropriate record. So if you know why they're seeking the record, then you can solve their problem for them. But you cannot force them to tell you why they are filing the record. That would have to be voluntary on their part. Okay, I like to describe the right to know process as an obstacle course. And this obstacle course, it has the start, it has deadlines built into it, which are similar to time standards that you would find for races. And on this obstacle course, there are 2 hurdles. In front of the second hurdle, there are 3 hoops that we have to make it through before we can even jump over the hurdle. And at that point, we've determined we've got a public record and we've won the race by getting that public record and access to it. Okay, so let's go through this obstacle course. First, let's talk about the start. Once the agency receives the request, it needs to immediately go to the arrow. Okay, there should not be any undue delay. We want to get the request to the open records officer as soon as possible, because that's when the first deadline kicks in. Now, the open records officer, once they receive the request, they should note the date on the request. You know, either put it in pencil or a date stamp or whatever you want to do in order to record the date you received the request. Because at this point, the first deadline is that you have 5 of your business days to provide an initial response. Now, when we say your business days, these would be days that you're typically available to provide public service for the administrative side of operations. So let's say, you know, you're a small borough in the northern tier of Pennsylvania, and maybe you're only open 2 days a week. Well, those would be your business days. Let's say you receive a request today. Well, tomorrow, provided you're open, would be your first business day. And then let's say Friday would be your second business day. Then we go to next week, Thursday, Friday. Then we go to the third week, Thursday. At the close of business, 2 weeks from now, that would be the end of your 5th business day. So you should have provided an initial response within that window. So for a business day, it's when you're open for business, Monday through Friday. If you happen to be a 24/7 operation like a police department, weekends don't count. If your administrative offices are closed for a holiday, that doesn't count. If there's a weather emergency and your administrative offices are closed, that doesn't count. School districts, let's say during the summer break, you're only open a limited number of days per week. Okay, those would be your business days. So you would provide your initial response, and you want to maintain a copy of the request and all associated paperwork related to the request. Now, under the right to know law, there's language in there that says 30 days or until all appeals have been exhausted. When we talk about appeals, that would be an instance where you have denied access to a record. They have the right to appeal, and we're going to talk about appeals towards the end of the presentation. But it could go for, you know, a couple years if it's working its way up through the court system. So you want to hang on to everything until there are no more active appeals. All right, but let's say there aren't any appeals. There is another law in Pennsylvania that you might want to pay attention to, and it's the Pennsylvania Municipal Records Act. And that governs how long an agency retains any records. And in there is a clause relating to right to know materials. Now, this only applies to municipalities. For instance, it doesn't cover school districts. It doesn't cover authorities. Okay, they are covered by other laws, except school districts. I don't think there's a law that governs file retention for them. But anyway, getting back to the Municipal Records Act, in there's language that says, hold on to all your right to know materials for 2 years. I'm going to recommend that you defer to the language in that law. And if you're a school district and there's nothing controlling, I would still say, 2 years. There's no legal requirement, but I think 2 years is a reasonable period of time to hold on to all of your right to know materials. After that, you can purge them accordingly. Okay, now let's say that you cannot provide a final response within that initial 5 business day window. The right to know law allows you to take unilaterally a 30 calendar day extension. Notice it's different. It's calendar day, not business day. So a calendar day would include those days you're not typically open for business. It would include Saturdays and Sundays. It would include holidays and weather closings. In order for the extension to be valid, there are some conditions that need to be met. First, in order to successfully invoke the extension, you need to take it during the business day window. You can't wait until like what would be the 6th business day, suddenly realize, oh gosh, I forgot about this right to know request. Well, we'll just take an extension. Unfortunately, you've already denied the request by default. It's what's legally known as a deemed denial through your failure to provide a response within the 5 business day window. You need to notify the requester in writing that you're taking the extension. And, if it's submitted by email, you can reply by email that we're taking the 30 calendar day extension. You need to provide a reason as to why you're taking the extension. And you go to section 902 of the law and it lists 6 reasons and you simply choose the one that's the most appropriate. It could be, we keep these records off-site and it's going to take us longer than 5 days to go through them to determine what's appropriate to release. Or we want our solicitor to review these to make sure we're not giving out anything we're not supposed to. Those are 2 common examples. Then you provide a date that the requester can expect to get the final response. Usually that's on the 30th day of the extension. An estimate of any costs that the requester can expect to incur, and it is just an estimate. It's not a hard quote. You settle up when it comes time to give the actual records. So you've got the 5 business days, and then you have the 30 calendar days tacked on. Okay, they begin on what would otherwise be the 6th business day. And that's how we calculate the 35-day window or requirement that agencies have in order to provide a final response. Now, don't get into the habit of automatically invoking the extension if you don't have to. If you've got a record that is readily available and clearly is public, why not provide it during the 5 business day window, okay? But I realize also that, you may not have the bench strength to get to everything as fast as otherwise we would like. So, if you have to use the extension, it's there, it's available for you. But if you don't have to use it, don't get into the habit of automatically invoking it because that upsets people, okay? And you don't need that headache otherwise in order to try and throw cold water on the process because quite frankly, these people aren't going to go away. They need the public record and they need your assistance in order to obtain it. All right, so on the obstacle course, we're now at that first hurdle. And we've got to answer the question, is this person asking for a record? What's a record? Well, we go to the definition section of the law. And I always tell people, if you're trying to understand a law, maybe you'll encounter language that is unusually vague or very legalese, or maybe you feel there's a conflict in the language of various provisions. Go to the definition section of that law, and it will probably shed light on the confusion that you're encountering. Within the right to know law, there's nothing different about that. And there's an excellent definition section, and it so happens they have a definition of a record. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, what does this key phrase mean? Documents a transaction or activity of an agency. Well, it means it's about the mission of our department, our borough, our township, our city, our school district, okay? And you're thinking, well, why wouldn't it be? But stop for a second, because it's common that all day long we generate communications that don't necessarily rise to the definition of a record. Some quick examples. I type an email to one of my coworkers. Hey, did you hear about the restaurant that's opened up downtown? Let's go have lunch tomorrow. All right. Absolutely nothing to do with our government agency. Or what do you guys think of the trades that have been occurring and how that's going to affect the Eagles this fall? All right. Yeah, we talk about, we communicate through various means about similar topics like that, and they have nothing to do with the agency. So therefore, because they do not meet the definition of a record, they're off the obstacle course, okay? They didn't make it over the hurdle. And we don't need to worry about non government-related communications being released through the right to know process. And it's not unusual to receive a right to know request where I want to see any and all emails generated by XYZ employee during this time frame. Well, if those emails include non-record communications, then they are not considered responsive and they're not provided in response to the right to know request because they have nothing to do with a transaction or activity of the agency. So you see how this works with the first hurdle. You have to answer the question, is it a record? If it's not a record, it's off the obstacle course, not considered responsive, and therefore not provided in response to the right to know request. So that's the first screening that you do. Now we come up to the second hurdle. But remember, before we even get to the hurdle, we've got 3 hoops that we have to go through. The most common one, and understand that with this hurdle, we're answering the question, is it a public record? Okay. So in order to determine if a record is public, there are 3 questions we have to answer before we even get to the big one. The first is, are there any exemptions that apply? And if so, are we going to invoke them? All right, what the heck is an exemption? Well, we go to section 708B of the Right to Know law. And by the way, the Right to Know law is, you can find it on the OOR's website, and you can download it free of cost. And it's not a hard law to read. I mean, it has its moments, but for the most part, it's written in common English, and it's fairly easy to understand. So Section 708B includes 30 exemptions. An exemption is a definition of a type of record that can be withheld from public access if the agency chooses to. And if you look at these exemptions, they cover an incredibly broad spectrum of records that all pretty much make common sense. So if you receive a right to know request and a red flag goes up, I don't think this should be a public record. I don't think we should release this. There's probably a good chance you will find an exemption that applies. For instance, I'll just give you a couple examples. There's one exemption that, and I'm paraphrasing, but it basically says if by releasing a record you would put someone in physical danger. Well, yeah, you're not going to release that. Or educational records. Okay, we're not going to release records like someone's college transcripts or records about a minor. Okay, we're not going to release any records that would provide information about someone under the age of 18. All right, all pretty common sense stuff. Okay, so if there is an exemption that applies, you can invoke that exemption, and that would be the agency meeting its legal burden to prove that a record is not public. Okay, so that's the first hoop. Now, question has popped up here. So if you email someone in the office, is that considered part of the record? Well, no, Audrey, it depends on the content of the email. Okay, I should emphasize that. It's not how a record is generated or where that record is stored. Rather, it is the content of the record that determines whether or not it is a record or whether it's a public record. Okay, so for instance, I have a smartphone and I can use that to send a work-related email to one of my colleagues. Now, it's my smartphone. I pay for it. But if I use that to email someone in my office about a work-related issue, that conceivably is a public record, even though it's my personal phone. Let's turn the tables a little bit, though. Let's say I'm sitting at my desk using a work-owned computer, okay, owned by the Office of Open Records, but I send an email to one of my colleagues about the restaurant. Okay, let's meet for lunch. That has nothing to do with the work of the office. That is not a record because the content has nothing to do with the Office of Open Records. Hopefully, Audrey, that explains the distinction there in some of the situations that you may encounter. Remember, it's the content of the message that determines whether it's a public record or not. Okay, so now back to what we were talking about. The second hoop that we have to go through is answer the question, are there any federal or state statutes or possibly a judge's order that makes these records non-public? You go to section 306 of the Right to Know law, and there's a reference in there that basically says the Right to Know law does not change the confidentiality status of any other record, of any record determined by another law. And again, I'm paraphrasing there. In English, it says, if there's another law that says this record is confidential, that trumps the Right to Know law. And there is a wealth of other laws that you should be aware of that make records confidential that may not be included in the exemptions for the Right to Know law. But just as examples here of other laws, if you're here today from a police department, you're more than likely familiar with the law known as CRIA, the Criminal History Records Information Act, that defines a wealth of records that typically are touched by police departments. That law basically says those records can only be shared with other police departments. They cannot be shared outside of that universe. Or, you run into medical records and you've got all those federal, the alphabet soup of federal laws that say you cannot share medical records, HIPAA, ADA, FMLA, and the like. So we take a look at what is the person requesting. Yes, these are records, but there are other laws that say we can't give these records out. And I think it's important to emphasize that these laws usually do not have discretion. Okay, you must withhold these records. Otherwise, you're in violation of the law, whereas the Right to Know law is discretionary. The Right to Know law says you can give out these records if you want to, but you can also withhold them if an exemption applies. These other laws, if you should refer to them as the basis of denying access, you are meeting your legal burden. The agency is meeting its legal burden by referring to the confidentiality provisions of these other laws. Okay, we had a vexatious requester who ultimately requested copies of all emails sent and received by school personnel or the school board that contained his name. We fulfilled it under the advice of our solicitor. But do these communications truly meet the definition of a record? It is possible, Kathy. Again, it depends on the context in which the name was referred to. And did the message, again, reflect a transaction or activity of an agency? Okay, if it's going to be hard for me to come up with an example here, but if that name, let's say, was part of a conversation that did not involve school business, then it may not have been a record or a public record. For instance, and I'm really stretching here, but bear with me. Let's say that two employees of the district had a conversation about, and it was an email conversation about this individual that did not involve a school activity. Let's say in my community, there is a private soccer league. Okay, so let's say one of the teachers saw this individual at a soccer match, not related to the school at all, and they emailed that to a coworker. Okay, that would be an example where this individual's name was mentioned in an email that did not involve a transaction or activity of the school district. So that would not rise to the definition of a record. You follow me on that? Okay, that's an unusual example, but it's the best I can do on the fly here. Okay, but for the most part, I'm going to say rely on the advice of your solicitor. They are the person best qualified and closest to the situation to provide the best advice. Any insight that I'm providing here is of a generalized nature. Your solicitor knows the specific, or should know the specific situations. They're the best source of legal advice. Okay, I'm not providing any legal advice here through this training. Another question, if I receive a request for information that would need to be supplied by our police department, Arrow, would I deny the request that comes to me and instruct them to resubmit to the PD? No, please don't do that, Erica. What you should do is forward the request to the appropriate Arrow as quickly as possible. Okay, no unusual delays. Simply get it to the right person. Okay, and that way the clock starts ticking when the request is received by the agency open records officer. So you get it to the right Arrow and let them process it, and it just, works its way out. Good questions, by the way, folks. Keep them coming. Okay. Judge's orders, perhaps the issue that the person has submitted the right to know request is also in litigation. Occasionally, a judge will issue what's called a discovery order, which is a legally binding order on the parties that says you can only have access to these particular records. That judge's order, again, trumps the right to know law. You can refer to the judge's order as the basis for denying access to other records. Again, this is something that would probably best be determined by your solicitor as to whether that judge's order may apply or not. And then finally, we need to answer the question, is the record protected by privilege? Again, we go back to your solicitor. Any communication between an attorney and their client of a sensitive nature is typically covered by attorney-client privilege. Any legal advice, any legal guidance. So in a government setting, it would be your solicitor or chief counsel providing guidance and legal advice to the management of the agency. So you want to answer the question, is this protected by attorney-client privilege? Again, the best person to ask if you have any doubt would be your solicitor. Take the communication to them and have them provide their insight. You know, if the requester disputes the denial, they can appeal it. And our office ultimately will determine whether or not attorney-client privilege applies. We're legally able to do that. But that would be the third hoop before we get to the hurdle. Okay, another question has popped up. Are audio recordings after minutes are approved part of the right to know request? Yes, they are, Debbie. You've got a public meeting, and let's say that it's recorded by the agency, usually for purposes of referring to them to generate the minutes that are required as part of that public meeting. Until that recording is disposed of, from the moment that meeting adjourns, during that window, that recording, as long as it's in possession of the agency, is a public record and would have to be provided in response to a right to know request. So then the question comes up, how long do you hold on to the recording? Well, if you follow the Pennsylvania Municipal Records Act, it says until the next public meeting of the board or for as long as administratively necessary. Okay, and it can vary. I mean, there are some agencies that will hold on to the recordings forever because they're digital files and, you know, they don't take up much space. They will put them on their websites so that I can listen to the recording as a citizen at any time. Or, you know, they may erase them as soon as the next meeting has occurred and the board has approved the minutes, whatever. Okay, but for the most part, recordings are considered part of the public record until the agency no longer has them in their possession. Okay, so we've answered these three questions: exemptions, other laws, attorney-client privilege. Then and only then, if we've said that, you know, we've made it through the three hoops, can we jump over the second hurdle? And at that point, we're saying it is a public record and it can be released into the public domain. Okay, back to another question here. Assisting Debbie, our district has a policy stating that we delete audio recordings as soon as the minutes are approved. Okay, that is acceptable, but you should also be aware that under the right to know law, it doesn't say anything about the minutes being approved, because conceivably you could have a subsequent public meeting where the board does not approve the minutes. Now I'm talking about the minutes here, not the recordings. The minutes are considered a public record whether the board approves them or not. The right to know law simply says at the time the next the next time the board meets. As far as the recordings go, that policy that you have, Kathy, that's consistent with the right to know law. It's not necessarily consistent with the Municipal Records Act, but again, being a school district, the Records Act doesn't specifically apply to you. Okay. Since the federal COVID declaration ends in May, and finally in July with the extended deadlines, we were told to keep audios during the pandemic. Okay, I'm not sure what you mean by the federal COVID declaration. You've got me there. I'm not aware of anything like that even existing. I think, you know, state agencies and local agencies, Judy, you know, maybe you can email us with what you're talking about, because we used the state declaration of emergency related to COVID, which has long since expired, as the guidance for application of the right to know law in the Sunshine Act. You've got me there. I'm going to have to do some research on that. Okay, but thanks for bringing this up. I'm going to be looking into that. Okay, back to the slides here. Interesting. Yeah, I got to get back. I got to get my head back on the slides here. You've got me thinking at a million miles an hour here. Okay, so we've determined that there are no exemptions that apply, or if there is, we're not going to invoke them. There are no other laws that say these records are confidential, and they're not protected by attorney-client privilege. Therefore, we can now jump over the second hurdle. It's a public record, and it can be released in response to the right to know request. So before we release the records, though, let's take a look at the payment side of the right to know law, because the right to know law is not free. Okay, so the first thing we want to take a look at is that there is a section 701, and I'll paraphrase here. It basically says that the agency is only required to provide the record in its current medium. Here we're talking about hard copy versus electronic. Okay, so the example being that a person submits a right to know request electronically. They say, I would like these records and I want them sent to me electronically. And they do that for two reasons. Number one, it's easy. And number two, the agency can't charge for electronic records. But let's say that the records only exist in hard copy. And I'll use building permits as an example. We have a building permit program. Someone submits the applications on paper forms. It goes to our codes department. They review the request and they issue an approval or denial or whatever. And that's all paper driven. When everything's done, we take all the paper, we put them in a folder, and we put it in a file cabinet. There are no electronic records. So per Section 701, the agency is not obligated to scan those paper records in, because that would be converting them from hard copy medium to electronic medium. Okay, you see what I'm saying there? So per Section 701, your response would be, we do have these records, but they're only in paper form. We'll provide them to you, but you have to pay for them. Okay, and that's how that would work, because we're not obligated to scan records in because we don't have them in that particular medium. See how that works? The next thing that you might want to be aware of, and I apologize for jumping around here, but this is a common issue, is that the right to know law affords two results. One is that I want copies of the records. The second is that I want to come in and inspect the records. Okay, well, there's no cost for inspection under most circumstances. What the law says is that if I'm in your offices inspecting a public record, I can make my own copy of it if I want to. So I can pull out a cell phone camera and take a picture of it. Or if I want to bring in my own copier, I can do that as long as it's not disruptive to the office operations. When someone has requested an inspection, the agency is still in the driver's seat. They can determine when during normal business hours, it's convenient for them to allow for the inspection. They can supervise the inspection to make sure that no records are stolen, destroyed, or altered in any way. Okay, but the agency's in the driver's seat here. An agency cannot charge for labor, for any redactions, and redaction is where you're going to release the record, but maybe there's some sensitive piece of data on there, like a social security number. So we're going to black it out. That's called a redaction. You can't charge for doing that. And you can't charge for legal review if you want your solicitor to look at something before you release it. You can only charge actual costs. Something like postage is an actual cost that you can document. So you can add that to your invoice. Okay? You kind of got the hint here through my conversations. No surprises. There is nothing in the right to know law that prevents you from reaching out to a requester and having a conversation over something that may not be clear. It could solve a lot of problems before they percolate up to the top into a full boil. Okay, communication is good. Let's say you get a right to know request and you're not sure exactly what the person is asking for. Nothing prevents you from picking up the phone, giving them a call, or sending them an email. Say, do you mind clarifying this point so that we can process your request? Same thing works for the requester. A requester can put special notes on their request that clarifies what it is they're looking for. Communication is good. Now, ideally, the person puts in the request, it's granted, so the exchange is mutual, okay? Here's your records, here's your money, and it works out well. But if push comes to shove, payment is provided before the records, okay? And that is paraphrasing a provision in the law. Now, let's say that an agency gets a request and they review it and it appears that the response is going to exceed $100. I like to look at this as a security deposit. The agency, if it so chooses, can demand full payment in excess of $100 up front before they begin processing the response. Okay, and like I said, it would be a security deposit where the right to know law kind of looks at this and says, we don't want the agency getting stiffed for generating an excessive response and then the person not paying for it. So you can demand an estimated check up front in excess of $100. And then record discard, basically, if the person doesn't make arrangements to pick up the records and provide payment, after 60 days, you can dispose of those records. But bear in mind, the person still owes you the money, and that does not go away. Okay, Anna, if electronic form is present, but the requester wants in paper form, then charging for the document can apply, correct? Yes, it can, okay? You're not, for instance, emails is an example. Let's say that the records only exist. A person is requesting emails, but they want them printed out. Well, by printing, you would be creating that record in a new medium, which you're not required to do per Section 701. But if you choose to do it, well, then the charges do apply, and you would go to the fee schedule on the OOR's website. Okay, good question. We don't run across that a whole lot. You know, people usually prefer electronic, but you know, conceivably, that's how it would work. You can charge for the paper records, but you're not required to print them out if they don't already exist in paper medium. Okay, so back to the slide here. If a person has incurred a debt for records that were provided that they didn't pay for, the agency can deny further right to know requests until that debt is settled. But bear in mind, if you do deny based on non-payment, the person can appeal that. And the appeals officer will be looking for all of your documentation that shows that debt is valid. So you want all the copies of the requests, the agency communications, any documented timeframes, how you calculated the costs, et cetera, et cetera. Now, if you've done that, if you've dotted all your I's and crossed all your T's, the appeals officer more than likely will agree with the agency. And that's been my experience. And you can actually research this on our website, go to the final determinations database, search and just put in the word fees. And dozens of final determinations will come up where the Office of Open Records has agreed with the agency on the denial of right to know requests because of outstanding fees. Okay, moving on here. Denying access, you know, let's say, oh, another one's popped up, that's okay. How do you handle responses that may be a mix of electronic and paper copies? If an electronic report would satisfy part of the request, however, the rest of the request would be hard copies, do you send the electronic piece and wait for payment to release the paper copies? Lindsay, what I would recommend is that before you begin processing and you know that there's going to be costs, get back to the requester with an estimate. Explain to them that, you know, some of the records are electronic and we can send those out, but there are others that are hard copy and that's going to cost you money. Are you willing to pay for them? And you do that before you begin, before you start investing time and money in generating the hard copies. Okay, because they may not be willing to pay. So you would break it out. Okay, we're approving this part of your request, but this other part, if they're not willing to pay, we're denying it based on you informing us you're not willing to pay for it. And if they have an issue with it, they can file an appeal and we'll sort it out. Okay. But that's more common than people realize. So it's a very germane question. But the way to solve it before it becomes an issue, have that communication with the requester. Let them know where things stand. Let them know there's going to be a cost and whether or not they're willing to pay for it. If not, your problem is solved. You could interpret that as a withdrawal or a partial withdrawal. Another question's popped up. Would the agency have to provide evidence that they have tried to collect outstanding right to know debt prior to denying the next request? Only to the extent that an invoice was provided to the requester that a debt exists. That's only, you don't have, if what you're asking is, do you need to hire a collection agency or anything like that? No. Your only obligation is to prove that there is a valid debt and that the requester is aware of it. Okay. And I think you would meet your obligation there. Yeah, I can't think of any other examples where that would not be the test. Okay. Okay. Thinking out loud here. Okay. So back to the presentation. What about a denial? What if we didn't make it through the hoops and we're not over that second hurdle? So you issue a denial letter. The denial letter has to follow a certain format, and there's reasons for that. First, a description of the requested records. Well, you're thinking, well, that seems rather obvious, but sometimes you get those requests where it's not necessarily clear. So for instance, our office, when we receive right to know requests, we include language, something to the effect of, we believe your request is for the following records. Okay, that's how we're interpreting it. So you want to include, your perception of what the person is asking for, because, there may be disagreement on that. Then you provide the legal and factual grounds for denial. Why isn't it a public record? Typically, you would be referring to those exemptions within the right to know law. And you make that nexus between the records that are being requested and that part of the law or the other law that says these records are confidential. Then you provide the contact information for the ARO, because remember, that's the person legally responsible for responding to the right to know request. Then the date of the response. This is important because now another deadline kicks in, which I'm going to talk about here in a second. And then the procedure that the person has for filing an appeal with the applicable office. 99% of the time, it's going to be the Pennsylvania Office of Open Records. So let them know that they have 15 business days to file an appeal with the Office of Open Records. Here's the URL for their website, and you've met that obligation. Okay, another question's popped up here. I have a request for 18 years of the township budgets. First, I will have to do an extension to find the information, and I think you're telling me I can charge for copies as it is all hard copy. Yeah, I mean, one of the things that's going to, well, first offhand, the question's going to come up, do you have the records? But you're going to have to conduct a good faith search. But yes, if they are hard copy records and they're accessible and you can make copies, then you can charge for them. It's up to 25 cents a page, 8.5 by 11, single-sided, black and white. That's your starting point. But look at our fee schedule just to make sure we're all on the same page as to what you can charge. Okay. But yeah, I can't think of anything else there. I think that pretty much answers your question there, Mary. Okay, let's move on here. I want to talk briefly about appeals before we finish up here. You've denied the request, so the person now has the right to file an appeal. 15 days from the date of your response, provided you gave them one. And they do that by going to our website. When we receive an appeal, we look for 4 elements. We need a copy of the original request. We need a copy of the agency response if one is provided, because sometimes agencies don't do that. The person needs to tell us why they think the records are public, and then they need to tell us why they think the agency's response is incorrect. If they fail to do that, the first thing we'll do is issue a deficiency order, and we'll give them 2 or 3 days to correct the deficiency, give us the paperwork that we need. If they fail to do that, then we will dismiss the case as deficient. However, if they do fulfill all the elements, then the case gets docketed. What docketing means is that the case gets input into our system. It gets assigned a docketing number, which is like AP 2023, and then a 4-digit code, and it gets assigned to an appeals officer. Then we send out notice of appeal to all the parties. Now, if you're joining us today and you are an agency employee or public official, or if you are an ARO and you receive notice of an appeal, either through email or through the public mail, because we don't have your email address, once you receive notice of appeal, run, do not walk to your solicitor, their office, and inform them that we have a legal appeal from the Office of Open Records. Everything I've described through the presentation up to this point has been what we'll call an administrative process. Once an appeal is filed, that is a legal process, okay? And from my perspective, here with providing a training session to you, that's administrative in nature. However, the majority of work done in this office is of a legal nature. The Pennsylvania Supreme Court defines us as an independent quasi-level tribunal. To put it in English, we are a court. And when someone files an appeal, they are more or less suing you. And there are tight deadlines that the agency has for responding to this appeal. So the ARO is not expected to respond. The solicitor is. And they need to do that because this is now a legal process. And they need to use certain forms, certain format, certain language, all the stuff that lawyers know how to do, but AROs may not know how to do. Okay, and you don't want to lose an appeal based on a procedural error. So give it to your solicitor. There still may be stuff you have to do, but your solicitor will now become the point person. And do not delay it, because you could inadvertently abrogate your rights to respond to the appeal. Okay, so probably the most useful piece of advice I can give you today is run to your solicitor with this appeal so that they can get to work on it right away. Okay, another question's popped up here. To clarify payment issues, if a prior request has an open unpaid amount, can the next request be denied due to having an outstanding balance or no? Well, the answer is yes. If there is an outstanding debt from that requester for the same agency due to a prior right to know response, you can deny any subsequent response until that debt is settled. Hopefully, Nina, that clarifies what I've been saying. Okay? All right, so back to appeals. The product of an appeal is called a final determination. That's what our office does. These are legally binding final orders, meaning they carry the weight of law. You can take one of our final determinations, put it before a judge, and they must consider it as precedent. Okay, they are issued within 30 days, or we may ask for an extension in order to issue the final determination, but the parties have to agree to that. If you've ever seen one, they look just like what you would see coming out of a higher level court, your county court of common pleas, Pennsylvania Commonwealth Court, whatever. Okay. You can find them on our website. They're in that final determinations database that I mentioned. It's like over 30,000 of these. They're in a searchable database. You can search on your municipality. You can put in your name. Maybe that'll come up. You can search on a particular legal issue. You can put in a random text string, like the word fees, and see what comes up. But they're all out there. If you have access to any of the legal services like Lexis or Westlaw, all of our final determinations are listed in there, just like other court decisions, okay? There is the option of mediation. I just want to talk about this real quick. That would be where when the person files an appeal, we ask them, would you be interested in mediation? And then when we issue the notification of appeal, we put information about mediation in there for the agency. And if both parties agree, the case gets pulled from the normal process and gets assigned to a trained mediator. Sometimes it's just a matter of getting the parties to talk to each other, which they failed to do up to this point. Maybe it's just a conference call. And once they start talking to each other, they come to an agreement. Okay, you're not required to agree to mediation, but it's out there and it's been fairly successful for us. You might want to take a look at it. Okay, our decisions can be appealed to higher level courts. If you're a local agency, it goes to your Court of Common Pleas. State agencies would go to the Pennsylvania Commonwealth Court. It has to be filed within 30 days. The Office of Open Records is not a party to the dispute. The dispute still exists between the requester and the agency, but you must notify us if you do file an appeal, because we will either monitor, we may file briefs, or we may petition the court for an appearance if we believe it's an important, a particularly important point of law. Okay, but that's how the appeals would work. Okay, a couple other questions have popped up before we wrap it up here. On the right to know request form is the 18 years of budgets, but also asks for 18 years of expenditures on a bridge, which I don't think I can even find all that information. Okay, Mary, I can't answer the response for you, but speaking very generally, the first thing you're going to have to do, you have to conduct a good faith search. You have to at least make an effort. As the arrow, you're responsible for knowing what records you have. And maybe we don't have anything on this bridge, but you've received the request, so you have to do a good faith effort. So you've done that, and you've determined we don't have any records on this bridge. Well, then that would be your response. It basically is a response of non-possession. And you say something to the effect, we've conducted a good faith search, and we've determined either these records don't exist or we're not in possession of them. And if you interpret that as a denial, here are your appeal rights. And that happens all the time. But otherwise, that's the best you can do, because you can't provide records that you don't have, and you're not required to create a record in order to respond to a right to know request. So it comes down to a matter of possession, and that's would be the basis for your response. Okay, Monica Phillips, who pays all the fees for the court mediation? Okay, well, there are no fees for a mediation, and there are no fees for an appeal to our office. But if it goes to court, it's the moving agency or the moving party. If the requester disagrees with the Office of Open Records supporting the denial, then the requester needs to pay the filing fees. If the agency disagrees with the fact that the Office of Open Records granted the request, then if they want to take it to court, the agency files the agency pays the filing fees to the appropriate court. So it's whoever the moving party is, whoever disagrees with our decision ends up being the person who pays. Okay, and then I don't want to get your hopes up, but there are instances where the moving party can also petition the court to pay all filing and attorney fees. but it's very rare that courts will do that. Okay, but that answers your question. I just don't want you to get your hopes up saying that, well, we can file an appeal and we can make the judge, or we can ask the judge for the agency to pay all the fees. That it just doesn't happen that much, because there are legal tests that must be met for a judge to award attorney fees and court costs. Okay. All right, we are at the end of the presentation, but if you have further questions, and I got to tell you, you've submitted a lot of really good ones today, but now's the time to get them in. If we end the presentation and then suddenly questions pop up, well, there's information on the screen now about the Office of Open Records website. Use that website. There's a lot of good resources on that website. The Final Determinations database. There's a case law index in case you're a solicitor and you want to see how the courts have ruled on the right to know law. There's just a wealth of resources there that you can refer to. If you can't find the answer to your questions there, then on the website, there are references to email accounts and phone lines where you can contact the office directly. And as I was saying at the beginning of the presentation, we will get back to you within a reasonable point of time, because we realize it's probably a pretty important issue that you're contacting us about. Okay, Vicki, I have attorney fees for an appeal and we win. I charge them for notifying our solicitor, correct? No, not in relation to the right to know law. I'm gonna just say that. Otherwise, I think it's best that you talk to your solicitor as to what they can charge, what you can charge for. When it comes to, you don't pay, and this is really outside the world of the right to know law. So I want to be very careful in what I say, because I don't want this to be interpreted as any sort of legal opinion or advice. Okay, I'm not providing you a legal opinion. I'm simply saying be very careful with whatever charges you give to the opposing party, because you may not have a legal basis for doing so. Okay? Only the court can determine who pays what, ultimately, when it comes to litigation, in most cases. Okay? So be very careful, Vicki, about what you think you can charge for. Again, talk to your solicitor. They're the person who can provide the best insight on something like that. Okay, may I please be included in your response regarding the COVID declaration? Okay, that goes back to Honesdale Borough and what they mentioned. Yeah, Janice, share that with all of us when you find that documentation, because I'm curious about that too, and I'm going to be doing my own research on that. I am not a full-time OOR employee, so I'm not always in the loop on stuff. I'm a consultant at this point. But when the opportunity comes up for me to provide some information on that, I'll do the best I can. What I'll do is I'll research it in my own time, and then I'll let the staff here know that, hey, this came up during the webinar. If there's any way to share this with the group, we do that periodically through social media and emails and so forth. And I'm curious about that too, because when it came to the COVID declaration, there were elements of it, the state emergency declaration, that applied to the right to know law. For the most part, it was concerned with the Sunshine Act, the Public Meetings Act. But, the Office of Open Records made specific accommodations for the right to know process. But I'm not aware of any federal declaration that we referred to that was controlling. But we'll do the best we can there, because I'm kind of concerned that we may have missed something. We had, there were state hearings before the legislature and discussions with the governor's office, et cetera, but there was never anything at the federal level. And I'm thinking, since we were talking specifically about school boards, that the School Boards Association may have provided some guidance that we're not aware of, because, in all honesty, our office and the School Boards Association's legal team did not always agree on how to apply various legal provisions related to COVID. And those issues still are out there. They've never been settled because they were never formally litigated. And I think where we left it is that we agreed to disagree until such time as the courts would weigh in, and they were never provided that opportunity. So I am curious about all that because, it may come up again someday, and it's good to flesh these things out beforehand, so that you kind of have at least some tacit agreement before you encounter them again. But okay, it looks like we've exhausted all of our time here as well as the questions. I want to thank you for your participation. Again, really good questions here, and I appreciate it. Folks, we'll be back in 2 weeks with another webinar. In the meantime, I hope you're enjoying spring. Looks like things are finally warming up and turning green. Have a great time, and look forward to seeing you at the next session. We're going to log off now. Take care.